enrichment, and the abuse of power. So I want to talk about your record. Under you, the department has prosecuted people that have caught folks on both sides of the political aisle by surprise. Jim Comey, Letitia James, my colleague Adam Schiff, Federal Reserve Governor Lisa Cook. This casts a shadow over your ideas, any ideas of independence. You directed the arrest of Mayor Ras Baraka of my city of Newark. You weren't at Delaney Hall on May 9th, 2025, when he was arrested, but yes or no, did you have a conversation with Special Agent in Charge Ricky Patel ordering him to arrest Mayor Baraka?
I had a conversation. I didn't order him to arrest. I authorized the arrest, which is my job.
So you were not there, and we have body camera footage of him then moving and saying, "We are arresting the mayor right now per," this is his quote, "the Deputy Attorney General of the United States." I want to put that into the record, your comments there. And the district court, assessing all of your conduct, admonished the Department of Justice. This is the quote of the judge, of the federal judge. "Your role is not to advance political agendas. Your allegiance is to the impartial application of the law and to uphold due process for all." But this is just one example cited by over 1,200 current and former Department of Justice officials appointed under presidents of both parties who warned that you should not be in this position because of your inability to be independent from your personal allegiance to Donald Trump over the rule of law. I met yesterday with Epstein survivors. Some of them are here in the room today. Congress, in a bipartisan fashion, passed the Epstein Files Transparency Act because the American people were demanding justice. Yet you failed to abide by that law and release the files by the deadline established by the law. And when the files were finally released, you failed to protect the survivors that law was intended to protect. Survivors' personal information, including names, phone numbers, home addresses, and images were released. Powerful people were redacted. Survivors were subjected to re-traumatization. More than 1,200 victims, yet only 2 people have ever been prosecuted, Jeffrey Epstein and Ghislaine Maxwell. Now, I was stunned earlier by your conversation with one of my colleagues that you wouldn't even commit to meeting with the survivors, but you did meet with Ghislaine Maxwell. Your claim that you can't meet with these victims because they're represented by counsel is utter nonsense. Counsel can be present or a client can waive their right to have counsel, but you're a lawyer. You know this. That was not truthful, what you said to my colleague. You said that they should meet with the FBI. All of these women have reported their crimes decades ago, but yet you won't meet with them. What you will do is meet with Ghislaine Maxwell. Over a year ago, you sat with her, and you publicly said you were seeking the truth. So let's talk about what that 2-day meeting produced. Did your interview with Ms. Maxwell lead to a single additional person being charged, yes or no?
No.
Did it lead to a single new investigation, yes or no?
I can't talk about whether there's any investigation.
I'm not asking you about an ongoing or closed investigation. I'm just asking you about this unusual...
I can't answer your question, yes or no.
Did you or anyone else from the DOJ or associated with the president discuss a presidential pardon with Ghislaine Maxwell or her attorneys?
No.
Did you discuss clemency, yes or no?
No.
Did you discuss...
She was convicted. What do you mean clemency?
Did you discuss her transfer to another institution, yes or no?
No.
Well, just 1 week after your meeting, Ms. Maxwell was transferred from a low-security federal institution to a minimum security prison camp. Were you involved with that transfer?
When, as I've talked about before, in the time leading up to me going down to meet with her, we learned that she was receiving threats. It turned out when we were
I'm going to
there,
interrupt you for a matter of time because...
Okay, well, it's not a question I can answer, apparently, in the time you're giving me.
I'm going to tell you this because I deal with issues of criminal justice. When people are under threats in a Bureau of Prison facility, they're put into solitary confinement, or protective. They're not moved to a camp.
That's not always true.
It is,
You're just wrong.
what is true is someone that is accused of child sex trafficking under the Bureau of Prisons' own policies is not put in a facility like this that seems clearly like a reward. The Department of Justice is also responsible that powerful corporations play by the same rules. Let's take a proposed merger between Paramount, Warner Brothers, and Discovery. This is no ordinary transaction. It was a proposed $111 billion merger involving two of the last remaining legacy Hollywood studios. As Deputy Attorney General and later Acting Attorney General, you exercised oversight of the Antitrust Division. You approved the decision to close the department's investigation into that merger, yes or no?
I was part of the decision. I
Yes,
don't know
you were
whether-
involved in that.
You
That
don't
is a
even
yes.
let me answer, man.
Did
That's
the
incredible.
career attorneys
The
who
answer to-
investigated that deal recommend closing that investigation?
I didn't have a conversation with the career, but as I was saying
I didn't
earlier,
ask you that. I asked you, did the career attorneys who investigated the deal recommend closing the
I
investigation?
have no idea what they
You were in
recommend.
charge of that department, yet you have no idea. Well,
I
this
didn't
is,
say I had no idea. It's no idea about the question you asked about what the career attorney's view was.
you do not know what the career attorney's view was.
I'm not sure what the view was with respect to closing it or not closing it.
Let me tell you why ethics laws that bind you about the appearance of impropriety are so damning in this case. On the same day that Paramount shareholders voted to approve the merger, David Ellison, the head of the acquiring company, hosted a dinner that you attended honoring the President of the United States. While you were at that dinner, the DOJ was still investigating a merger. Did you speak with Mr. Ellison on that evening?
No.
Did you discuss with anyone involved in that organization that evening the department's ongoing investigations?
No.
Well, 6 weeks later, after that dinner, that investigation was closed, that you're stating you have no idea if the attorneys in charge even finished their investigation.
That's not what I said.
What did you say?
You asked me a question about whether the attorneys recommended that the investigation be closed, and I said I wasn't sure. That's different than what you just threw back at me.
Do you believe that that creates an appearance of impropriety that you were at a dinner?
No.
Okay. The Justice Department ethics rules are very clear about avoiding the appearance of impropriety. In a case like this, I don't think that's appearance of impropriety. I think that's improper. That the connected and the powerful are getting a chance to rub shoulders. It would seem appropriate that you avoid those kind of appearances and dinners like that.
Every appearance or dinner or speech that I give are cleared by ethics officials.
So your attendance at that dinner was cleared by ethics officials?
Everything that I do.
I didn't ask you everything you do. Was your appearance at that dinner
You
cleared?
can ask the questions, but you cannot control my answers. I'm under oath, and I can answer the questions. I choose to answer them.
Were you
So what I will tell you
approved
is when I do
yes
things
or
outside,
no?
when I
Were
do
you
things-
approved
when
by
I do
ethics
things
to-
outside of the department, whether it's a speech, whether it's a dinner, whether it's an event, they are approved by ethics officials.
You did not answer whether that attendance was approved.
Every time I go out, it's approved. Yes.
You know, Lincoln, it was said about him that if you want to see the true character of a man, don't view him in adversity, give him power. I believe you've had a lot of power. And so we don't have to speculate about what has been revealed with your time in that office. We don't need to worry about what kind of attorney general. You've already had that power. This isn't a job interview like usually. You've sat before this committee before. You've made promises time and time again before. You got the job, actually, to be the number 2 and the acting director. So this isn't a confirmation hearing. This is more of a performance review. And clearly, when it comes to the treatment of Epstein victims, when it comes to politically motivated prosecutions, when it comes from avoiding appearance of impropriety with corporations, you failed. You're asking this body for a promotion. And you've spent today making a lot of promises, promises to follow the law, promises to be independent, promises to serve the American people and not the president. But we don't need your promises. We have your record. We have watched you exercise one of the greatest powers entrusted to any public servant. And what have you shown us? 1,200 victims waiting for justice. What have you shown us? there's two prosecutions. While the people involved, the victims, are waiting for action, one of the people prosecuted gets the most cushy arrangement possible after you visit with her. Again and again, you seem to be favoring the interest of a president and the powerful. You've chosen Trump over truth. You've chosen corporations over the Constitution. And you failed to meet the test. I'll say this in closing. This is why your nomination should fail. The Attorney General's client is not the president. It's the American people. You've been protecting one man for most of your career, for years and years and years. He has demonstrated himself to put undue pressure. This is why he was impeached. This is why he was criminally indicted. If your record and your testimony today should show us anything, it should show you, in my opinion, that you should not be confirmed to this job.
Thank you, Senator Booker. Before I commence with my questions, I've been asked by Chairman Grassley to enter something into the record. On behalf of Senator Grassley, I'd like to enter into the record a letter supporting Mr. Blanche's nomination. This is from the Newark Police Superior Officers Association, which represents the leaders of the Newark, New Jersey Police Department. The letter touts Mr. Blanche's experience, character, temperament, and leadership. It goes on to state, quote, Mr. Blanche has consistently demonstrated an unwavering commitment to the rule of law, the fair administration of justice, and the constitutional rights afforded to every citizen, including the due process rights of law enforcement officers. Throughout his distinguished legal career, he has earned a reputation for integrity, professionalism, sound judgment, and respect for the rule of law. These qualities are essential for the nation's chief law enforcement officer, close quote. Without objection, I will enter this into the record. Mr. Blanche, at the outset, earlier you were asked by one of my colleagues about the settlement agreement and about the definition of some of the terms. Now, as I've been going through that, it seems to me that some of those terms were defined earlier in the agreement, albeit not in the section of the agreement that you were shown on the board. Is that correct?
Yes, Senator.
And those make a difference, do they not, to the nature of the question asked to you?
Yes, of course, yes.
You have no reason to believe that the so-called weaponization fund will continue because of the settlement agreement. Is that correct?
I am confident it will not.
Right. Now, during the previous administration, we saw an unprecedented and unfortunate weaponization of the U.S. Department of Justice, an institution near and dear to my heart, as I know it is to yours, and an institution that's got a long and storied reputation for impartiality. Public trust in law enforcement plummeted as a result. That should concern every member of this committee and, indeed, every American. The Arctic frost investigation swept up more than 400 Republican-aligned groups and individuals with blanket investigations, fishing expeditions in some instances, designed to intimidate and silence conservative voices or anyone deemed not favorable to President Biden and those who served with him. Investigators even violated the sanctity of Congress in a brazen move that tramples on all sorts of protections, including the fundamental separation of powers. As Chairman Grassley's investigation continues, just yesterday, we learned that Jack Smith's team bypassed a required filter review and directly accessed the text, not metadata, not information about who texted who and what time they did so, but the actual content, the substantive content of texts of 44 members of Congress, 6 of them on the Senate Judiciary Committee, all without notice in a baseless fishing expedition. This was un-American, and it comes uncomfortably close to spying on a co-equal, coordinate branch of the U.S. government. As you know, protecting individual liberty and our constitutional rights is a top priority of mine. I appreciated your testimony in May before the CJS Appropriations Subcommittee, in which you called the secret collection of phone records from a dozen members of Congress, quote, the worst form of abuse, close quote. I sponsored the bipartisan NDO legislation long before Arctic frost, and I believe this must be fixed, no matter who holds the presidency in a way that protects all Americans. In fact, this calls upon us, underscores the need to pass that NDO reform measure. What steps have you already taken in your capacity as Deputy Attorney General and now Acting Attorney General? And what reforms do you plan in the future to end these practices and this trend of weaponization within the department?
Thank you, Senator. Well, there's a number of things we're doing. Most significantly, it's getting materials together and being transparent with this body and this committee like we did recently with the emails that you just referenced. Because one of the best ways that we can make sure we never do again what we did before is by exposing ourselves and letting the American people see what we did. We're also taking steps to right the wrongs. So that means, again, going back and issuing reports and issuing findings and conclusions around not only what the Department of Justice did at times, but other agencies within the executive, and calling ourselves, holding ourselves to account that we shouldn't do it again. And the most important thing, and it's come up a lot today, but it is just having prosecutors prosecute bad guys. And so it's getting prosecutors out of D.C. and into U.S. attorneys' offices and unleashing them to do what they should be doing and what they should have been doing for the past 4 years as well, which is tackling the drug pandemic and epidemic we have in this country, going after the fraudsters. And that's the best way to make sure that the next Department of Justice continues doing the right thing and not the wrong thing.
That's wonderful. Sometimes when you're doing the things that are not supposed to be done, you're not doing the things that are supposed to be done. And I appreciate your efforts in that regard. On another topic, federal law prohibits non-citizens from voting in federal elections. Separately, a law called the National Voter Registration Act of 1993, sometimes known as the NVRA, requires, among other things, that the states keep their voter registration files clean, removing voters who have died, who have become ineligible, and to make those maintenance records available for public inspection. The Department of Justice has relied on that disclosure requirement to request state voter rolls and to confirm compliance with this mandate in the NVRA among the states. But a number of states have refused. And when the Department of Justice has sued in order to correct this problem, some federal courts have issued rulings indicating that the NVRA doesn't clearly authorize the NVRA. The NVRA doesn't clearly authorize this kind of compelled production of the complete voter registration files. So the department is thus left without a reliable, viable enforcement tool, even where noncompliance might be staring us in the face, as it is in some jurisdictions. Put simply, non-citizens can't legally vote. But a number of these states, blue states more than others, are doing everything they can to prevent the Department of Justice from enforcing the law. In the meantime, we've got an interpretation of other provisions of the NVRA that have made it, in tandem with this other problem, virtually impossible to enforce the law prohibiting non-citizen voting in federal elections. In your view, would the Save America Act give the Department of Justice clear authority in its efforts to protect the sanctity and security of those elections?
Yes, absolutely. Yes.
Thank you. I appreciate that very much. This is a very important issue. Now, under your leadership, the Department of Justice fraud enforcement has seen some real success. You've got a lot of success stories under your belt already. Can you describe how you're leading that effort in the department to combat citizen fraud, healthcare fraud, and fraud in taxpayer-funded programs and organizations?
Yes, we're making it a high priority. We're working with the White House and the Anti-Fraud Task Force and unleashing, again, having prosecutors focus on fraud. And so that means working with inspectors general, that means working with the FBI, DHS, to get these cases, take them to prosecutors. The fraud division itself is being built up. We've already had tremendous success just in the past 4 weeks in recovering billions of dollars that had been stolen from the FISC. And this is work that is just starting. We've always done fraud cases. This isn't a new thing for the Department of Justice to do, but the focus on these fraud cases and the focus on every U.S. attorney having multiple prosecutors focused on going after fraud cases is something new, and it's something that is important to President Trump, and it should be important to everybody, not a Republican or Democrat issue at all, and that's why we're doing it.
Shifting gears a little, tell us just very briefly about what the department's doing under your leadership to protect children from predators.
It's Listen, there is no greater responsibility prosecutors have than protecting our most vulnerable. And so we recently stood up, I have a leader, she's here today, running our task forces going after any sort of human trafficking or child predators in those cases, making sure we're coordinated. We are, again, focusing AUSAs on going after these cases. We've seen multiple investigations leading to prosecutions and even multiple sentences at this point, starting since we first took office over a year ago. And again, this is about spending resources where they should be spent. So instead of spending time in D.C. working on cases that we really have no business working on, we are out in the field protecting our victims, protecting children, and going after the predators that are in every community and putting them in federal prison.
I'd like to turn now briefly to Section 702 of the Foreign Intelligence Surveillance Act, FISA 702. And I want to address some of the repeated claims made by some of my colleagues that our intelligence collection under 702 would go dark when the statute lapsed as of midnight on June 12th. As you know, Section 702 operates under year-long certifications approved annually by the FISA court. Is that correct?
Yes, that's correct.
And the government most recently obtained approval of its 702 certifications in March of this year. Is that correct?
It did, yes.
So those certifications remain valid until they expire, right?
Correct.
And they don't expire until midnight on March 16th of 2027. Is that correct?
That is correct.
Okay. So in the event that the telecommunications providers don't comply, the FISA court can and would compel compliance and impose fines. Isn't that right?
We would certainly try, yes. We would come.
Thank you. I want to echo briefly what my colleague, Senator Coons, has commented with regard to the Safer Supervision Act to ensure that supervised release is focused on those who need it, promoting both efficiency and public safety. So thanks for your comments on that. I really appreciated those. And then also, some of my colleagues have mentioned a recent court order in the case regarding the leak of President Trump's tax returns and the ensuing settlement. Responding to that opinion, was there any improper coordination of any kind between the Department of Justice and the Trump team as to this settlement?
No, not at all.
Okay. So, in fact, the case itself was settled based on an apology, without any compensation being awarded, without the president receiving a penny. Isn't that right?
Correct, and completely consistent with the Federal Rule of Civil Procedure 41, which absolutely allows what happened here to happen. It happens in hundreds, if not thousands, of cases around the country every year.
For any entity, whether it's the U.S. government or otherwise, that's been sued for $10 billion or any significant sum of money, that seems like a pretty darn good deal. I see my time's expired. I believe Senator Padilla is up next.
Thank you, Mr. Chairman. Mr. Blanche, welcome. Do you believe every human life is sacred?
Can you repeat that, Senator? Sorry.
Do you believe that every human life is sacred?
Yes.
So do I. A lot of my colleagues have made remarks about our colleague who recently passed. This last week, we've also seen Lorenzo Salgado Araujo fatally shot by an ICE agent during an enforcement operation in Houston. Earlier this week, Juan Sebastian Guerrero was killed in another fatal ICE-involved shooting in Maine. I'm not here to debate immigration policy or how immigration enforcement has been conducted by this administration. My questions are specific to law enforcement policy and best practices. Given that these are officer-involved shootings, federal officer-involved shootings, what role should the Department of Justice play in ensuring independent and transparent review and investigations over these incidents?
It depends on the agency that the law enforcement officer was a member of. So if it's a FBI agent as opposed to an ICE agent or an HSI agent. And the role that we should play depends. It depends on the conduct. Normally, each agency has their own procedures for investigating any type of shooting. And it usually involves their inspector general or an internal office. At some point along the way, the DOJ
I don't want to cut you off
may play a role.
too quickly here, but I want to come back to that point.
Sure.
But first ask, should state and local law enforcement be involved in ensuring that there's an independent investigation of these incidents?
I mean, it depends. I think there's a lot of times when state and locals should definitely be involved, but I don't think unequivocally state and local have to be involved for independence. Of course not.
Here's the bottom line why I'm asking these two questions. Because in prior incidents, referenced Minnesota earlier in your testimony, Alex Preddy and Renee Good were also fatally shot. And as far as we can tell, it's been months and months, there's been no justice in these cases. As far as I can tell, those officers were not fired. They have not faced any charges. So it does undermine any confidence anybody should have in the Department of Homeland Security's ability, through the Inspector General or otherwise, to investigate its own. So I come back to the question, what should the role of the Department of Justice be when there's federally officer-involved shootings?
Well, I very much disagree with the statement you just made. The mere passage of time between January and today doesn't mean there's no justice. It doesn't mean that so these investigations do take time. And as Senator Klobuchar talked about, and it's her state, we meaning the federal government, have worked with the state and locals in that case.
Move on to other issues, but here's what I see. I mean, no justice, clear justice, and I get investigations take time, but no justice. In those two cases, what we have seen is people continuing to die, not just in detention facilities, but on the streets of America. Next topic, coming back to January 6th. There have been several of my colleagues who have asked about the quote-unquote slush fund. Do you personally believe that someone who forcibly entered the U.S. Capitol and assaulted law enforcement should be rewarded with taxpayer money? Yes or no?
I can't answer it yes or no, but if you want the answer, I think that the fund that doesn't exist anymore set up parameters where, no, somebody that you just described would likely not recover funds.
Which brings me to my other point, because several members have asked, and I know Senator Tillis specifically focused on the weaponization slush fund and language versus declarations versus appropriations bills on how to undo this. I also need to be clear that January 6ers should not be able to seek payouts from other sources, including the Federal Tort Claims Act. Do you commit to vigorously defending taxpayer money from being paid out to January 6 riders, those who were convicted of their involvement with January 6, regardless of the source of funding from the Department of Justice?
You're talking about a statute that exists and it allows anybody to seek to file a suit against the United States. So I can tell you we always vigorously defend our cases, but I can't speak to a particular case.
Well, we know this is a hypothetical. There's been at least 4 letters that I've signed on to, along with Senators Durbin, Klobuchar, and Whitehouse, who asked earlier about the status of January 6 riders seeking payouts from the department. When can we expect responses to those letters?
When you say status, you mean those that have filed cases in court? I don't know what that means.
The status of their request for payouts being reviewed, approved, or not?
I think anybody, including January 6 defendants, can file a claim under the Federal Tort Claims Act, and I think some of them have. Those cases are ongoing. They're publicly available on ECF.
And I know some people would suggest, well, they've all been pardoned for their crimes on January 6th, and so this may be fair game. Are you aware that at least 97 January 6ers have been accused of new crimes since January 6, 2021, including violent crimes, by the way, child molestation, et cetera? That sounds like the worst of the worst to me.
If anybody commits a crime, they should be investigated, arrested, and prosecuted. So if you're talking about people that committed federal crimes and they happen to have been pardoned before, they should be arrested and prosecuted. Yes.
Well, I look forward to that as well, and we'll follow up in questions for the record. Mr. Blanche, during our courtesy meeting a few weeks ago, you said that, quote, independence of the department was a misnomer in the context of the Department of Justice because the president sets policies and priorities, and your view, the Department of Justice must enforce the law in a way that carries out the president's goals. Do you recall that conversation?
Yeah, I definitely did not say that, but nice try.
No, that's exactly what I recall from our conversation. So I want to be on the record saying
well, I'm happy
disagree.
to tell you what I said to help your recollection.
So the Department of Justice should be independent or not?
I think as I said earlier, the Department of Justice is under the executive branch. If confirmed, I will be member of the president's cabinet. So absolutely, my obligation is the American people and the rule of law.
So we'll
But
talk
that
about
being
the if
said,
con-
I am a member of the cabinet of the president of the United States.
We'll talk about the if confirmed in a minute, but let me also point out the Department of Justice's own website states right on the homepage that what the department's core missions is independence and impartiality. So let me bring a specific example. Last fall, President Trump issued a statement for National Domestic Violence Awareness Month, where he said, quote, "I'm steadfastly devoted to uplifting survivors of domestic violence and ensuring they know they are never alone and that help and support are always within reach," end quote. Sounds like a statement that we'd all agree with. But the Office of Violence Against Women is a vital component of the Department of Justice that administers grants to organizations that provide services for victims of domestic violence, sexual assault, dating violence, and stalking. It provides critical resources to organizations that support victims. Yes or no? Are you aware that the office is substantially delayed in notifying grant recipients of awards that were intended to begin October 1st of last year?
We are rolling grants out on a rolling basis, and we continue to do so. We will continue to do so. We didn't have the grants authorized till January of this year, so
And it's now July, it's been 6 months. Next, yes or no question. Are you aware that as a result of the delays, many organizations have been forced to lay off staff and reduce services for domestic violence victims? Yes or no?
I am not aware of that, no.
Okay. We're happy to provide you information and cases. Are you aware that many notices of funding opportunities for the fiscal year 26 have yet to be posted for grants that are supposed to begin on October 1st of this year?
I know that we are posting, that we are caught up from the last fiscal year. The budget wasn't approved until January of this year. We had to finish last year's first. We're putting them out every single
Again,
day.
it's been 6 months. Are you aware that multiple congressional offices from both sides of the aisle, this is not partisan, on a bipartisan basis have reached out to the office about delays and have not been given any concrete timeline despite the real and substantial impact that these delays are having on domestic violence services?
That's not true. I've testified publicly about it on multiple occasions, and we have given a timeline. I just gave you the timeline today, which is that we're doing it every day on a rolling basis. We're caught up to last year's,
So
and
I'd
we're
like to see a
moving
more
forward, and we
specific schedule
anticipate
so
having
that
all of them done
organizations in
by the end of this
California
fiscal
and
year.
every other state, for that matter, can know when to expect their funding. I know my time is running out. Let me just end with this. Mr. Blanche, it's the duty of the Attorney General of the United States to, quote, "operate free from partisan consideration and protect citizens' rights to equal justice." But what I've heard today fails to inspire much confidence in your ability to carry out that duty or to put federal law before loyalty to the president. I add to that facts from the judiciary. District courts in 31 cases have recognized that the administration has violated court rulings. The Solicitor General refuses to rule out, refusing to abide by court rulings circuit court rulings that they disagree with. In immigration cases alone, the administration has admitted violating court orders in the District of New Jersey alone more than 50 times. This does not sound like a Department of Justice. The American people deserve better. And a lot of nominees come before us and say, well, if I'm fortunate enough to be confirmed, then this or that. I'm not buying that. I know you're not confirmed for the top spot. You're acting in the top spot. You were the number 2 from nearly the beginning of the term. Yes, a lot of this accountability falls on your shoulders. The American people deserve an Attorney General who put the Constitution above political retribution. I don't think you're fit for this job. Thank you, Mr. Chair.
We'll go next to Senator Moody. Before we do that, I've been asked by Senator Grassley, the chairman, to enter into the record a letter supporting Mr. Blanche's nomination from the United Coalition of Public Safety, which represents many of the nation's largest law enforcement organizations and tens of thousands of law enforcement officers across the country. The letter highlights both Mr. Blanche's qualifications to serve as Attorney General and his unique approach to the criminal justice system. It states, quote, "We believe Mr. Blanche will serve with honor, fairness, and a steadfast commitment to the rule of law. His leadership will undoubtedly enhance collaboration between law enforcement and the Department of Justice, ensuring that our communities remain safe, while reinforcing public confidence in our own system. Without objection, this letter will be admitted into the record. And Senator Moody, you're recognized.
Thank you, Mr. Chairman. Good to see you again and get to talk with you about your nomination, Mr. Blanche. And everything that I warned about in my introduction seems to be proving true, that good faith and nuance is just going to be thrown out the door as a price to be paid for clicks and tweets and promotion of some partisan agenda today. Because, and I'll quote from one of my colleagues, they said to you, protecting one man for most of your career. Would you define your career as protecting one man, Mr. Blanche? And if not, why not?
I mean, absolutely not. I mean, I am a prosecutor. I'm a career prosecutor. I started out as an intern down the street at the Department of Justice. I was a paralegal. I was a law clerk. When I was representing President Trump, I had other clients as well. So the fact that I represented President Trump for a period of time, under 2 years, does not define my career, nor does it define me. I should be defined by the work that I did as a prosecutor and by the work that I've done leading this department since March of last year.
I think one of the true crises that we face as a nation right now, and you can pick the subject matter at which this would apply, but the American people, who are supposed to be where the power lies in this country. It was how extent of fraud that has been uncovered. And I commended Nick Shirley, and this is a young, he described himself as an independent journalist, but he started out disrupting, young at like 15 weddings, I want to say. And I think that spirit of challenging the status quo or formality has really driven him to disrupt what I think the American people believe is a bureaucracy historically that has not only maybe because of its size, maybe because personnel in there aren't too quick to want to uncover, but has really been not inclined, complacent, or is set up to not uncover and really go after some of this fraud. And I've been astounded by the amount that this administration has uncovered. And I commend people like Nick Shirley and James O'Keefe that have been out there because they're American citizens and they believe that their government owes them accountability and stewardship of taxpayer money, first and foremost. And he said, I can't believe that for so long, nobody paid attention to this. And we're seeing just fraud that is just something that we haven't imagined. And I'm really proud of this administration and the DOJ, specifically under your leadership, for setting up a specific division now to go after these things that are raised. The results speak for themselves. I mean, you've established a new National Fraud Enforcement Division charged with bringing a comprehensive approach to rooting out fraud. We just saw a 2026 National Healthcare Fraud Takedown where you charged 455 defendants in connection with schemes involving more than $6.5 billion in fraud. I believe we brought together the most states and territories ever in the history of the department's existence in going after fraud. That was all under your leadership and this administration. And I think that delivers a remarkable message, not only to the people out there committing these this fraud against the American taxpayer and really against the next generation that's going to inherit this. I mean, I'm a mother of a teenager right now. I feel terrible that they're going to inherit all of this, because before Biden ever pushed out swaths of money that went to corruption and fraud, an American taxpayer had to earn it, or we had to borrow it on the backs of our next generation. And so I am proud of the department saying enough is enough. The free ride is over. We are digging in. We're going to take, not only are we just going to, talk about it, we're going to actually show you what we're doing, and we're going to create an entire different division. I think it speaks volumes that you have the new head of your fraud division with you today in the audience. I think America should know that. That didn't exist before you. I would like for you to tell the American people right now a little bit about that, because I have to tell you, when some of these states learned about this fraud going on, when Nick Shirley showed up and exposed some of this insane fraud that was happening right under state administration government's noses, the reaction from state leadership, and the governor of Minnesota called Shirley far-right delusional conspiracy theorist, maybe because he campaigned on these small businesses that were set up with that money so that the American people, like, we are growing small businesses, make me your vice president. Maybe that's why he had to knock Nick Shirley down a notch. Governor Newsom came out and said, slow Shirley is the fraud. He tried to ridicule and demean this 24-year-old kid who was just uncovering fraud. And these are chief executives of states. So I'd like for you to explain what you're doing differently. Because right now I just came from a hearing where not one Democrat was in the room to ask this bipartisan witness panel about the fraud that's happening or what we could do about it. Not one Democrat was in the room. And we've got elected officials around the state, when people are trying to bring it to their attention, calling out the people bringing it to their attention, and not only that, trying to pass legislation to stop them uncovering it. In California, they have a Stop Nick Shirley Act, which should be called the Protect Fraudsters Act, I assume. But tell us what you're doing different and how you're going to work to uncover and root out and go against criminals in these states where these elected officials are complicit, maybe aiding and abetting, because they're going after the people that are trying to raise the issues.
Yes. So before we talk about California and Minnesota, it's worth talking about states that are working with us. So places like Florida, places like Ohio, where we're working closely with the local government, getting information about individuals who are committing fraud, applying for money from the federal governments, where the state serves as a pass-through. And what President Trump and the Vice President did last fall was said, enough is enough. We need an all-out government approach to combat fraud. And so part of that is our new fraud division. And the work that they're doing is exactly what you just described. And some of the stuff that Nick Shirley has uncovered has been incredible. But it's going into these states and identifying, at this point, just low-hanging fruit. So fraudsters that have set up daycare centers, that have set up autism centers.
And leering centers. Maybe.
Learning centers.
Hearing
centers, everything. And all they're doing, and there's no patience. They're just collecting money off the backs of taxpayers. And then you have, it's true, the governor of Minnesota did nothing but obstruct our efforts month after month. And then when we did a takedown and we executed a law enforcement action on a given day, he hopped onto X and said he was happy to partner with us. He's not partnering with us. He's not working with us. And so that's very disappointing. The same thing with the governor of California, where the amount of fraud that's being stolen out of the generosity of taxpayers around this country is in the billions of dollars. But listen, without talking about that, what we can say that it's extraordinarily positive is that we have arrested hundreds and hundreds of fraudsters just this year alone, and we've got a lot more to do between now and the end of the year. And that's the work of, again, our federal agents, our inspector generals, DHS, HSI working with us, FBI, and then our prosecutors who are now have been given full authority and have been unleashed to tackle this problem. There is no fraud too small. Colin McDonald says it, and it's right. If you commit $1,001 of fraud, you should expect to go to federal prison. And we're going after the biggest fraudsters and the smallest fraudsters, because any dollar that's taken inappropriately is something that this Department of Justice won't tolerate. So it's a big effort, and it's going to take a lot of work. We're hiring a lot of prosecutors. We're using a lot of AUSAs around the country. But I expect that we'll continue to see the results that we're already seeing. So thank you very much for the work that you guys have done as well to help facilitate our success there.
Thank you, Mr. Blanche.
Senator Welch.
Thank you very much, Mr. Chairman. Thank you very much, Deputy Attorney General. I want to talk to you a little bit about the Anti-Weaponization Fund. Just by way of background, you've had a long-standing relationship, of course, with President Trump, served as his personal criminal attorney, right?
I met him for the first time a couple years ago.
Right. And in the course of your representation of the president, you earned over $9 million, correct?
Well, my law firm was paid that much. I had 6 or 7 lawyers.
Well, that was in your financial disclosures. I don't have a problem.
Oh, no, I was paid it. Sorry. But I'm saying it went to my law firm. I had employees.
Right. It's been raised that you have a close relationship with the president, but you're entitled to that, and the president is entitled to appoint as Attorney General a person in whom he has some trust. So that's not an issue for me. But on the Anti-Weaponization Fund, there is the question of whether a president who is suing the taxpayers, the IRS, for $10 billion, and where his formerly personal lawyer is representing the taxpayers, is there a conflict of interest? And my understanding is that before you actually got here, you did get ethics training when you were, after you were acting Deputy Attorney General, correct?
Yes.
And my understanding is that you were advised that you should not be engaged in matters that affected President Trump in his individual capacity. Is that correct?
No, I'm not sure what your understanding is based upon, but no. There's very clear ethics rules that I was required to follow that I do follow.
It's based on a letter from Mr. Terrell, and you received normal ethics training.
Yes.
And normal ethics includes that you do not represent someone with whom you have been representing them before in a personal matter, right?
I'm not trying to get uber technical, but there are very technical rules around the ethics requirements, and I follow them.
All right. Well, maybe you could provide us with what the ethical materials
I can tell
were
you
that
right
were
now if you're
provided.
interested.
What I'd like you to do is send us the materials. Let me go on. If you had an issue, there was a dispute involving, say, Paramount, would you have a lawyer from the Justice Department who owned $9 million in stock negotiate on behalf of the government with that company?
It depends on as long as there's an ethical and no reason there was no conflict.
So if I had
then
$9 million in stock with Paramount, I'm representing the people, there's an adversarial relationship, you'd let me negotiate on behalf of the people when the outcome of those negotiations would have an impact on my stock price?
Sorry, I just want to understand your hypo. If a lawyer for the Department of Justice has $9 million in Paramount stock, they should not be on that case.
Right.
I agree. Yes.
Okay. And, you know, what happened here with the president that's so mystifying to many of us, it would be analogous if the governor of Vermont sued the Department of Taxes for $10 billion. And we don't appoint attorney generals, but in New Hampshire they do, but let's say we did. And the governor is formerly personal attorney.
There's no comparison between.
Let me finish my question. The governor sues the Department of Taxes for $10 billion. His former personal attorney, who's now appointed Attorney General, negotiates with the Department of Taxes and ends up settling by setting up a fund in the control, essentially, of the governor for $1.776 billion. That doesn't sound fishy to you?
Well, the hypo you just described, I don't think it's appropriate to use the word fishy. It's either ethical or not ethical,
Well,
and there's
you know
no.
what? Vermonters would just say it stinks. I mean, that is truly bizarre, that the chief executive gets his appointed person who was formerly his personal attorney to negotiate on his behalf, where at the end of the day, taxpayers are going to pay. So I'll just leave it if
But
that.
the other thing I'll correct, though, is you use the word as if I negotiated. I wasn't part of the negotiation, which I've said before.
Your
so-
department is. You had to sign
Yes,
off on it.
that's true.
That is your signature.
Yes, that is my
So whether,
signature.
I mean, look, you're at the top of the pile here. So
Yes.
you don't get involved in all the phone calls and all the details. But at the end of the day, you have to do due diligence and satisfy yourself that you in good faith can sign off on the agreement.
Correct.
And you did. So
Yes.
that is your responsibility, and I'm sure you accept
Oh, I
it.
do have responsibility for it.
That's
I agree
right.
with that, yes.
All right. And, you know, let's talk about the pardons. I understand the president, any president, has total authority to pardon anyone he or she wants. And that includes commuting sentences and it includes restoration of gun rights. You know who Liz Oyer is,
Yes,
and you know who Mel Gibson is.
yes.
All right, Mel Gibson was convicted of domestic violence. What he did was he punched his then girlfriend in the teeth, threatened her with a gun, while she had their infant in her arms. Now, it's the president's decision. He can restore Mr. Gibson's gun rights. That's not your decision. But my understanding is you had a pardon attorney who, when requests were made to restore gun rights to domestic abusers, they'd be vetted. Mental health issues, other issues, and that's because 500% increase in homicide rates of domestic abusers who have guns. You asked, or one of your people asked, Liz Oyer, to provide a letter that basically said, okay, we can restore his gun rights. Is that correct?
That happened the day I was starting. I know
was
Ms.
2
Oyer
days.
has claimed
It was
that
2 days after.
I know that Ms. Oyer has claimed that that had anything to do with her firing. I didn't even know of that. I had known nothing about Mel Gibson or that letter when I fired her. Nothing.
So why did you fire her?
For a number of reasons. For one,
You were there
her,
2 days?
yes, for a number of reasons. It had nothing to do with Mel Gibson. The decisions that she had made as pardon attorney in the weeks and months leading up to the end of President Biden's term were completely inconsistent with President Trump's authority, including recommending commuting every single individual on death row, which even President Biden didn't do.
I'll let the Americans be the jury of whether that sounds right. But 2 days after
It
you
is
were
right.
there, she got fired. She was told to do a letter that was basically going to validate the decision the president had made to restore gun rights to a man who smashed his girlfriend's mouth, threatened her with a gun, and did it with her holding their infant.
And had nothing to do with why she was fired, by
Right.
the way. Nothing.
Now, what also is documented is that she was going to testify here in Congress before a roundtable. And people were dispatched, federal marshals, to go to her home at night. It turns out she was not there. Her 11-year-old son was there alone. And fortunately, at the very last minute, that access to her house or that the trip to her house was canceled.
That's not true. I mean, if you want me to
part of
answer
it-
with the truth, I can.
What part of it is not true?
When we learned that she was going to testify about privileged communications, like we do anytime a former employee is going to violate their ethical duties, we drafted a letter. We tried to serve that letter on her via email. We tried to contact her. She would not answer her phone. So the way the Department of Justice serves people in every case is with Deputy United States Marshals. We endeavored to do that, and then she accepted
Okay.
service.
Thank you. I'll go on. Kash Patel, I do want to go back to my colleague Senator Weiss has some concern. I have concerns about him because of the reports about his drinking, about the incredibly bad morale there. But I'm not going to ask you on that. You are a supervisor, so obviously you have some responsibility to be reviewing this behavior.
I don't think
But-
he has any issues drinking. He has no issues with
All right,
morality.
but let me, here's what is very clear. He was at the White House for 8 hours, and this is after a report came out in the New York Times that talked about the $400 million Qatari plane that was Air Force One not having certain deceptive defensive capabilities. and issued subpoenas to reporters demanding that they turn over their news sources. I happen to believe it's extremely important to protect the right of the press to have confidential sources in order to get out information that is absolutely in the public interest. Do you support Mr. Patel's efforts to subpoena and get reporters under the grill to disclose who their confidential sources are?
The Department of Justice requires that I authorize it, which I did. And those reporters, we're not targeting reporters. They're material witnesses, just like a reporter would be a material witness to a car crash.
Yeah,
they
but
are witnesses. And so
And the question you want to ask them is who were their sources?
No,
That goes to the heart of the
no.
First Amendment.
no, the question we want to ask them is who provided them with classified national security information, which everybody in this body should want to protect. I would hope.
Senator Hawley.
Thank you very much, Mr. Chairman. Mr. Blanche, good to see you.
You too, Senator.
You're getting towards the end here. Are you still sure you want this job?
I do, Senator.
Good.
Thank
All
you.
right. Good. Good. Well, that was a rhetorical question, but I'm glad the answer is yes. I want to start with Jack Smith and the latest revelations of his illegalities, which seem to have no end. I mean, listen, I've had my text messages, did have my text messages by him scooped up, read. Who knows what he did with them? I've had my cell phone monitored. He tracked my incoming calls, my outgoing calls. He tracked my metadata. He tracked my location. I mean, Lord knows what else. The part that really offends me, though, is that he didn't just do it to me and members of Congress. He did it to ordinary Americans. I've had Missourians come to me and say, I had FBI agents show up at my door, knock on my door and say, were you in Washington, D.C. in January of 2021? These are people who did nothing wrong. They weren't even here. They come to me and they said, what is going on? What am I going to do? I can't afford an attorney. What really gets me at the end of the day is he lies about it. I mean, he has lied and lied about it. And I want to just make good that claim. Here is a record. I'm going to read it to you. A record of Jack Smith's responses under oath now to members of Congress. He is asked, question, as it relates to members and their staffs and senators, it's just the toll records as far as you remember. Smith, that is my recollection. Question, did the records that you requested include the content of text messages? Smith, answer, no. Now, maybe there's some nuance I'm missing here, but it sounds a lot to me like this guy didn't tell the truth. Have you thought about investigating this guy for perjury?
We take testimony in front of this body very seriously, yes.
Good. Well, I think he absolutely should be investigated. I think he absolutely should be prosecuted, if at all possible. And based on his responses under oath, I think he should be. And I think it's time that we say that these people who did this, who engaged in this mass illegality, blatant violation of the separation of powers, blatant violation of the Constitution. We know what they did to President Trump. We know what they did to everyday innocent Americans. And that's before we even touch the issue of trying to recruit spies into Catholic parishes, sending members of the anti-terrorism division to go hound parents who went to school board meetings. It's unlike anything we've ever seen in American history. And my view is there needs to be accountability for it. I hope that you will investigate Jack Smith for perjury, and I hope that possibly you'll prosecute him.
Yes, Senator.
Let me switch gears and ask you about a Missouri-specific issue. My state has a number of laws that protect the unborn. We're a very pro-life state in Missouri. And that includes laws that limit the use of the chemical abortion drug, the circumstances under which it can be prescribed. You need to see a physician and so forth under Missouri law. Now, as you know, Joe Biden gutted all of those restrictions. He took away President Trump's safety restrictions on this chemical abortion drug. He instituted a mail-order abortion policy. So my state went to court to try to defend our state's laws. A number of other states, Republican states, did this. And of course, in the meantime, the president changed, thank goodness, and now we have President Trump. But that means that now we have the state of Missouri, Republican state, along with a number of other conservative Republican states, are in court against a Republican administration fighting over Joe Biden's abortion policy. And by the way, while I'm on this subject, I just want to show you why it matters to Missouri. Here's what happened in Missouri after Joe Biden changed the rules and contravened our state laws. Look at the abortions. I mean, dramatic increase, because under Joe Biden's abortion rules, It doesn't matter what your state law is. Doesn't matter what the voters in my state do. You can just mail in this abortion drug, no prescription, no follow-up visits for the mother, no medical support at all. You mentioned this earlier, I think. You can mail these in from overseas, from India, for heaven's sake, and that's where many of them come from. Nationally, we see the same thing. Since Biden put his policy in place, massive increases in the number of abortions. Here's what I want to get at with you. I just hate that we have these Republican states. I hate this policy, first of all, but I hate it that we have these Republican states in court against a Republican administration. And it just seems to me there's got to be some solution to this. So I just want to ask you, what do you think that is? I mean, how do you think we can get to some solution here from all of this mess and find our way out of it? I turn it over to you.
I share your concerns, as does this entire administration. As you know, I mean, we have the most pro-life president in history, and you are one of the most pro-life senators in this body, and so that is a good thing. I don't want to talk about litigation strategy here; it's not appropriate. But it is. I will say, as we've said in our briefing, we are not defending what Biden did and will not. The FDA has a process that we're letting them go forward in, and this is, again, in our briefings. It takes a year. They've committed to do it significantly less time than a year, and we are will always. And when I say we, I'm not just saying the Department of Justice, I'm saying President Trump's administration in its entirety will protect the life of the unborn and work with states and obviously you to make sure that we do that in the best way. I want to get to a solution as well. I don't want to talk about litigation strategy here. I don't think that's the right forum, but I very much share your concerns, Senator.
You mentioned just a second ago, I think this is an important point. I just want to make sure I drive this home. You're not defending this abortion policy, Biden's abortion policy, which changed President Trump's own rule. You're not defending that in court, right? I mean, you're not defending that on the merits.
And it's in all of our pleadings that we are not, correct.
Yeah, and even the FDA commissioner said, I'm just going to quote him here, that Biden's rules as a legal matter lacked adequate consideration. The HHS Secretary, Bobby Kennedy, said that Biden's rules invite potential dangers by offering mifepristone without sufficient medical support or supervision. So those are from your filings. So I want to be clear on this. You do not defend this policy on the merits whatsoever. And presumably you have no issue with President Trump's earlier rule, which had common sense safety restrictions. You had to see a doctor, get a prescription. There had to be a follow-up visit to see if there was any hemorrhaging. Those were in place before Biden gutted them. Presumably, there's no issue with any of those.
I anticipate the department would defend those rules, yes.
So, okay, that leads me to this question. Why not, while the FDA is doing its review, why not put President Trump's rules in place? They're good rules. Why not do that rather than leave in place these rules? I mean, just explain that to me.
Well, this gets to my original point when I don't think it's appropriate to talk about our strategy, litigation strategy here, except to say that we want to get to a good result consistent with President Trump's administrative directive and priorities, and we very much believe that the Biden rules were wrong. So we're continuing.
Good. I'm glad to hear that. Do you have any thought about what a solution, a good result might be? I mean, do you have any? And I'm not asking you to discuss your litigation. I mean, apart from that, I mean, how are we going to get out of the litigation? I want to be clear. I want to get out of the litigation.
Understood.
I hate the fact that all these Republican states are litigating against the Republican administration. We got to find some way to end that. So maybe you have a thought.
I hope that the work the FDA is doing now, because remember, we have to have studies that we can defend in court. We have to be able to say to a judge, probably in this district, that our change was not arbitrary and capricious. So we're trying to let FDA, we meaning the Department of Justice, do their work so that we can have continue to protect the lives of the unborn children and, frankly, the state's laws, like Missouri's, which is really what's being violated here at its core.
Let me just ask you one other thing on this. I know that you've seen these stories, these news reports about women who are assaulted by their boyfriends or whomever. They get pregnant, the boyfriend doesn't want it, they take the drug, crush it up, lace it in their drink or what have you. One example, Rosalie Markovich, Rosalie, she got pregnant. She was excited. She did not want to have an abortion. She wanted to have her baby. Her boyfriend did not want that. So without telling her, certainly without her consent, he laced the drug into her drink. It caused her to begin to miscarry. He restrained her so she couldn't go to the hospital. I mean, this is assault. Multiple states now have brought dozens of criminal charges against men who do this. My question to you is, have you thought about devoting resources at the Department of Justice, putting together an initiative that might bring resources from the criminal division, the civil division, and the U.S. attorneys together, call it a Protecting Women and Children initiative that would work then with states to go after these coerced abortions, to protect these women, to help states enforce their laws, and to go after these criminals who are using Joe Biden's policies to commit assault left, right, and center.
I very much commit to looking at that. I share your concerns. The story you mentioned, I'm aware of that story. It's horrible. I think there's a lot of that is not necessarily a federal crime, but the federal government can certainly help in that space.
I think and I'll end with this, Mr. Chairman, I think that if you stood up, as a former state attorney general, I can just tell you that when you can get resources in investigation and prosecution, it's immensely helpful. You've had tremendous success with that already under your tenure in other criminal areas. I think that if you were to stand up a full-fledged initiative at DOJ, put somebody senior in charge of it, to go after these actors who are abusing the rules that Biden put in place, I think that would do a lot for women and children, their safety in this country.
Thank you, Senator.
Yeah, thank you.
Before I go to Senator Schiff, I'd like to enter another letter in the record. This supports the nominees from civil rights lawyers who litigated cases against the Justice Department across multiple presidential administrations. The letter states that Mr. Blanche has, quote, gone a long way to restoring faith in the rule of law and has been especially encouraging to pro-life cause, for which so long has been relegated to a second-class status, end of quote, without objection. That'll be entered in the record. Senator Schiff.
Thank you, Mr. Chairman. Mr. Blanche, you represented the president in at least three criminal cases, the hush money payment case in New York, the January 6th case, and the Mar-a-Lago classified documents case. You said when you appeared last before this committee you would consult with ethics lawyers about that apparent conflict of interest in handling any case involving the president, having been his personal counsel. Did you consult with Joseph Terrell, a senior ethics lawyer at the department?
I believe I met with Mr. Terrell, yes.
Did Mr. Terrell tell you that ethics laws and policies required that you not be involved in cases involving your prior representation of the president?
Yes.
So in those three matters, the hush money payment case, January 6th case, Mar-a-Lago case, you were to recuse yourself?
I'm recused, correct. Well, by the way, the cases are not ongoing, Senator, but to the extent there's any work around those cases, yes, I'm recused.
So you said to CPAC a couple months ago, the other things that are happening, there is not a single man or woman at the Department of Justice who had anything to do with those prosecutions, meaning the prosecution of the president. So you're saying that it's not a conflict of interest for you to be involved in the firing of prosecutors who prosecuted your client, your former client? There's no conflict there? Is that
No, there is. I wasn't involved.
So
that would be a
at
conflict.
CPAC, you're taking credit for the firing of these Department of Justice lawyers, but you're not willing to take responsibility before this committee. Is that the case?
No.
Okay.
I'm making, there's a
Well,
statement I gave
you
at
were
CPAC.
bragging about this at CPAC, the firing of these prosecutors, the firing of the FBI agents, the getting rid of everyone who investigated your client. You were proud of that, speaking for the Department of Justice, but you don't think that's a conflict of interest. You moved to vacate, I don't think you're going to deny involvement in this, you moved to vacate the convictions of 12 Proud Boys and Oath Keepers, which erased their convictions, restored their gun rights. These people were convicted in the January 6th investigation, which also involved the president, who you represented. You were involved in dismissing those cases, were you not?
I'm the acting attorney general, so yes, my department moved to dismiss. I was not
So
involved.
you didn't recuse yourself from that matter. You were
No,
willing?
there's no reason to, from the Proud Boys matter?
Yes,
I mean,
it was.
lawyer,
it
you know
was,
the rules.
it
There
was
are rules that say when I
yes,
have to
there
be
are
recused,
rules.
and that's not one of them.
And there are rules. And when you're told to recuse yourself from investigations
I
that
always
you
do.
handle for the president, you're supposed to recuse yourself.
No, when I
So
represented the president.
you have also said, you've also refused to release Volume 2 of the Special Counsel's report. That was an investigation into the Mar-a-Lago documents case. How is that not an abundant conflict of interest? Refusing to release to the public an investigative report of an investigation into your client.
I am not a judge. A federal judge.
No.
has said
The
it cannot be
department's
released.
position under you, Mr. Blanche, the department's position under you, Mr. Blanche, was do not release the report.
So that position,
If you went into court asking them to release it, it would be released by now. So how is that not a patent conflict of interest?
what you're saying happens to not be true. I did not do that. What you're talking about happened
So
before I became the
you
Deputy Attorney
support the
General.
release of Volume 2?
No, I don't, but I'm recused and it had nothing to do with that case. Like, you can't accuse me of violating my ethical rules and then lie about what I did.
So you had nothing to do with the decision to prohibit the release of the report? You had nothing to do with the department's
wasn't in court.
position?
I
No, I'm
wasn't
not
the
asking whether
deputy-
you were in court.
I was-
I'm asking you whether anyone sought your opinion or used your guidance in refusing to release Volume 2.
When
You're
that
saying you had nothing to do with
when
that decision?
litigation was ongoing, I was a private citizen, still representing the President of the United States. It was before March, since March, to the extent there's been anything in front of that judge,
Mr.
I
Blanche,
haven't been part of
I
it.
asked you in your last confirmation hearing whether you would release the report, and your answer was no. Your answer was not, I will recuse myself. Your answer was, no, I will not release the report. That was your testimony last before this committee. You subsequently were advised by ethics lawyers not to be involved in these matters, but it appears you were involved in these matters. Let me ask you about another matter.
I
you
wasn't
were-
involved.
Well,
You can't
let me-
say it
let me-
appears I was
okay,
involved
all right,
when I
well,
said I wasn't.
Let me ask you about another one you have your
I mean,
name on.
geez, the truth has to matter at some
Yeah,
point.
it does matter. We just don't hear much of it from you. But let me ask you about another matter you have your name on. I don't think you can deny responsibility here, and that is the IRS settlement agreement. So
Yes.
you put your name on this. That absolves the president of tax liabilities in the past. The president was convicted in the case you represented him in of falsifying business records in part for tax purposes. Does this settlement not absolve the president of any liability for tax crimes associated with what he's already been convicted of?
That's not what he was convicted of. It not having to do with
Well,
for tax
I'm happy to
purposes.
read the statement of facts. The participants took steps that mischaracterized for tax purposes the true nature of the payments made in furtherance of the scheme. So you know,
The
Mr.
participant
Blanche.
there was not the president. It was somebody else.
Well, if the president is conspiring with others to falsify business records to help them cheat on taxes, he is also exposed to liability. You know that as well as I do.
He can't be audited for that.
And of course he can be. Of course he can be. And he can be prosecuted for it. But the agreement you signed on behalf of your former client, on behalf of your current client, in a staggering example of self-dealing prohibits that. Let me ask you this. Does this tax agreement, this addendum you signed, also hold him harmless from any audit or tax liability with respect to the billions in crypto money he made in his first year as president?
It's not forward-looking. So to the extent there are taxes filed by the president or his sons or the Trump organization after the date of that agreement, there's no protection.
Well, but before that agreement, so any
So
taxes...
he hasn't filed taxes
so
yet
any-
for money he made last year, right? So
Yes.
no.
So if he...
So no protection.
If he filed tax returns this year for money he earned last year, that his sons earned, that his World Liberty Financial, all those people earned and defrauded taxpayers on it, he faces no liability under this
No
agreement you
evidence. There's
signed.
no evidence taxpayers were defrauded, and he
But
is not protected.
there's
He
evidence
is
in
not
this
protected.
agreement
He's
that
not
you've
protected.
absolved him of any liability over
No,
it.
I just said he's not absolved. So the question
So this
was,
agreement doesn't apply to a tax return filed last year
To
or
tax
filed this
returns-
year?
to tax returns filed after the date of the agreement? No,
No,
it does not
before the
apply.
agreement. A tax return filed in this calendar year before this agreement.
Before the agreement, it applies, not
Yes,
after.
okay, so for a tax return filed this year for last year, for the billions he made, there's no tax liability even if he cheats on his taxes or his kids do or his business do. He is absolved of that further potential liability.
No.
Well, it's in the plain language of your agreement. Did you write this language,
You
by
have
the
to
way?
use the facts, though,
Did
that
you-
he hasn't
did
filed
you-
taxes yet. So when he files taxes, there's no protection based upon this agreement.
Did you write this language?
Did I type it up myself?
Did
No.
you write this language?
No,
Well, you put your name to it.
I did.
So who wrote this?
I don't know the person that actually typed it. I don't know who it is
Was
someone
it,
within the
was it
Department
one
of
of the
Justice.
president's lawyers, or was it someone from the Justice Department or IRS?
This document would have been
Yes.
somebody within the Department of Justice.
Well, you have no idea who that is.
I don't know the name of the person that typed it
And
up.
did you debate with them the statute of limitations, which clearly would preclude the president's claim, this $10 billion lawsuit?
We had extensive discussions internally about the underlying litigation.
And did you reject the statute of limitations defense?
I'm not a judge. I don't reject
But
things.
you
I mean,
signed an
there was-
agreement
there
for
was-
the
There was
U.S.
discussion around the
You signed an
litigation.
agreement for the U.S. basically indicating that the Justice Department's position that the statute of limitations applies doesn't matter.
I did, that's not what I said. I didn't say
Well-
that anywhere.
Who rejected the 25 defenses the IRS had to this sham lawsuit? Who rejected them? Who said that these defenses we're not going to accept, we're just going to go with the president's agreement in the slush fund
There
and
was
this immunity?
There was a lot of discussion internally.
But you made the
about
decision.
case. What's the decision? What do you mean?
You made the decision to not defend the IRS and the Justice Department. You made the decision instead to sign this slush fund agreement.
We made the
with
decision to settle the case, correct?
Yeah. And in doing that, you basically decided that you were going to be the lawyer for the president and the lawyer for the IRS and the Justice Department. As the court found in this
No.
case, there was no adversarial relationship.
Yes,
the
there
court found it was a sham, it was a collusive relationship. And what I don't understand, Todd Blanche, what happened to the Todd Blanche who was a prosecutor in the Southern District of New York? What happened to the prosecutor people had respect for? What happened to the prosecutor who once respected the rule of law? What happened to the prosecutor who said that there wouldn't be a whiff of political partisanship and then prosecutes the president's enemies over Seychelles cases, over making a video stating the plain law and Constitution? What happened to the Todd Blanche of the Southern District of New York that could convert him into you, someone willing to say the president has both the right and the duty to prosecute his political enemies? I cannot
never said
imagine
that.
the Todd Blanche of the old days would have ever done that. What happened to you, Todd Blanche? I'll tell you this, I think Robert Caro had it right when he said that power doesn't corrupt as much as it reveals. I suspect it has just revealed who you are, and who you are is someone willing to sacrifice everything you once believed in for that title, for that position of Attorney General. And it is a sad story that we have seen from Trump appointee after appointee after appointee. We have seen people compromise themselves little by little, and then a lot by a lot, until they're sitting before this committee and trying to justify the unjustifiable. I yield back.
May I just briefly respond, Chairman?
Yes, you may.
Very briefly. So you asked me what happened to Todd Blanche. I am still here. I am the same exact person I was when I was a federal prosecutor in the SDNY, which is do the right thing and do everything you can to keep communities safe. So when I was a line prosecutor, when I was a supervisor, when I was the head of a division, my motivation and my goal was the same thing with the people who worked with me and worked for me, which is do the right thing, enforce the laws, and put bad guys in jail. And so you spend time talking about, I did not interrupt you. I did not interrupt you. A little courtesy would be appropriate. So when you ask me what has changed, okay, and you talk about a single document that I signed, okay, and somebody had to sign that document when the president sued, okay, so I tried to do the right thing. What I do every single day, and what the prosecutors in this country do every single day, and the nearly 100,000 indictments and informations that have been filed since January 20th, is exactly what everybody in this building should want the Department of Justice to do, which is to make our communities safer, enforce the laws, both civilly and criminally, and always do the right thing with integrity, which is exactly what I'm doing. So I am the same Todd Blanche I was when I was a federal prosecutor in the SDNY.
Before I call on the last Senator asked questions. I'd like to enter into record a letter supporting the nominee from Peter Furselli, retired law enforcement officer, as the NYPD homicide detective and ATF special agent. Mr. Furselli worked alongside Mr. Blanche when he was a prosecutor in the Southern District of New York. The letter states, quote, "I know Todd Blanche to be a quiet, thoughtful, soft-spoken man, but make no mistake, beneath that measured demeanor is a tenacious, fair, and deeply ethical federal prosecutor. He is the kind of lawyer who does not seek the spotlight, yet he consistently delivers results grounded in the law and justice." End of quote. Without objection, it's entered in the record. Senator Cruz.
Thank you, Mr. Chairman. Mr. Blanche, thank you for the job you are doing. It is rich seeing Senate Democrats complaining about weaponization and politicization of the Department of Justice after 4 years in which they were complicit in the greatest abuse we have ever seen of the Department of Justice. I want to do something that was strikingly absent in much of the questioning from our Democrat colleagues, which is actually focus on facts instead of made-up stories. And I want to compare where the department was under Joe Biden to where it is now under your leadership. During the Biden administration, the Justice Department devoted extraordinary resources to investigating and prosecuting President Trump and his supporters. Is that correct, Mr. Blanche?
It is.
The department authorized Operation Arctic Frost, which investigated members of Congress and other political figures. Is that correct?
Yes, Senator.
The department's senior leadership, Attorney General Merrick Garland, Deputy Attorney General Lisa Monaco, FBI Director Chris Wray, all personally approved the opening of this investigation. Is that right?
That's correct.
This investigation involved nearly 200 subpoenas, targeted over 400 Republican-aligned groups and individuals. Is that right?
Yes, Senator.
And then the FBI obtained, without our knowledge, the cell phone data of 20% of the Republicans in the Senate, including me and many of my colleagues on this committee, as well as now FBI Director Kash Patel and now White House Chief of Staff Susie Wiles. Is that correct?
Yes, Senator.
Just yesterday, Chairman Grassley revealed that even more senators' communications were targeted. Jack Smith's team obtained and reviewed the text messages of 44 members of Congress, including 19 Republican senators. When the Department of Justice loses sight of criminals because it is turned into a partisan arm of the DNC, the American people pay the price. It also meant the Department of Justice was not doing its job, which is enforcing the law and putting criminals in jail. During the Biden administration, there were roughly 12 million encounters at the southern border. Is that correct?
Yes.
Approximately 2 million illegal aliens were known to have entered but were not apprehended, the so-called gotaways. Is that right?
Yes, that's correct.
Fentanyl became the leading cause of death for Americans between the ages of 18 and 45. Is that right?
That's correct.
That was courtesy of the Democrats' open border policies of letting drug dealers and human traffickers flood into this country because they believed it would benefit them politically. Violent transnational criminal organizations, including the Sinaloa Cartel, the Jalisco New Generation Cartel, MS-13, and Tren de Aragua, expanded their operations inside the United States. Is that right?
It is absolutely correct.
And then something we never hear from the Democrat side of the aisle: the victims. Jocelyn Nungery, I've not heard one Democrat so much as utter her name. The little girl tragically raped and murdered by 2 Venezuelan gang members the Biden administration released. Laken Riley, again, the Democrats cannot even say her name. Rachel Moran, a mom brutally raped and murdered by another illegal the Biden Justice Department released. These were daughters, these were students, these were mothers, and they would be alive if the Department of Justice had done its duty. So let's compare the lawlessness, the partisanship, the abuse of power of the Biden Department of Justice to what has happened in the last 18 months. Mr. Blanche, objectively, the American people are safer today than they were 18 months ago. Is that correct?
There is no doubt.
Now, that's not simply empty rhetoric. Since President Trump took office, federal law enforcement has arrested approximately 29,000 violent gang members. Is that right?
That's correct.
The department has disrupted or dismantled approximately 2,700 gangs, a 365% increase over the comparable period of time in the previous administration. Is that right?
That's correct.
Arrests of Trinidad members have increased by approximately 519%. Is that right?
That's correct.
In 2025, the United States saw the largest one-year drop in violent crime and murder since 1937. Homicides across America's largest cities fell more than 19%. Is that right?
That's correct.
Robberies fell nearly 20%. Aggravated assaults fell nearly 10%. And that trend has continued into this year with homicides falling by yet another 17.7% and robberies by over 20% during the first quarter of 2026. Is that right?
It is, yes.
The department has also made protecting America's children one of its highest priorities. Since the beginning of this administration, the FBI has located approximately 7,200 child victims, a 42% increase. Is that right?
Yes.
The FBI has arrested approximately 3,500 child predators and human traffickers, a 102% increase. Is that right?
That's correct.
In April alone, Operation Iron Pursuit located more than 200 child victims and arrested more than 350 alleged child sex abuse offenders. Is that right?
That's right.
And across my home state of Texas, Operation Soteria Shield rescued 89 children and resulted in 276 child exploitation arrests. Is that right?
That's the correct stat.
Mr. Blanche, after less than 18 months, would it be fair to say that the department is once again focused on protecting the American people and faithfully enacting the laws?
That's exactly what we're focused on, Senator.
And I will point out that one direct result of that also is deaths by drug overdoses have dropped 20%. There are literally thousands of Americans who are alive today because of the job you and your colleagues at the Department of Justice are doing. And I, for one, want to say thank you for focusing the department on saving people's lives and putting criminals in jail.
We have great prosecutors, Senator, and great agents.
Now, I want to go to a topic that Senator Hawley asked you about, which is the Biden administration rule concerning the abortion pill. (18 U.S.C. Section 1461, Comstock Act, provides that every article or thing designed or adapted or intended for producing abortion is declared to be non-mailable. I have to admit, that statutory text to me looks quite straightforward. It is not subtle, it is not difficult, it is straightforward. As you know, during the Biden administration, the Office of Legal Counsel issued an opinion concluding that those provisions generally do not prohibit mailing abortion drugs unless the sender intends them to be used unlawfully. Is that right?
Yes, that's correct.
Now, Office of Legal Counsel opinions may be reconsidered when the Attorney General concludes they are inconsistent with the law. Is that right?
That is right.
Will you commit to carefully reviewing that opinion to ensure that it faithfully reflects the actual statutory text that Congress enacted?
Yes.
Likewise, as Senator Hawley asked, Louisiana versus FDA remains pending before the Fifth Circuit. Without asking you to comment on the merits of that litigation, will you commit that the department will carefully evaluate every lawful action available to ensure the faithful enforcement of the Comstock Act and other federal pro-life acts?
Yes.
And I want to point out the real consequences of the Biden administration's lawless authorization of mail-order abortions. According to FDA reporting, the abortion pill has taken more than 3.7 million unborn lives, caused 24 maternal deaths. Moms are being killed, and resulted in at least 4,195 adverse maternal reactions, including hemorrhage, excruciating abdominal pain, and severe life-threatening infections. The position of the Democrats now seem to be that women and teenage girls should be able to get mail-order abortions without a doctor being involved at all. And I will tell you, the death toll from that is horrific, and it needs to stop. Final question. Will you commit as Attorney General to faithfully and vigorously defending the Second Amendment right to keep and bear arms?
Yes, absolutely.
Thank you.
Mr. Blanche, thank you for your testimony today. And to your family and friends who are here, I thank you all as well. You should be very proud of your performance today. I think you performed admirably, showed this entire country that you're eminently qualified to serve as Attorney General. If confirmed, I'm very confident that you'll continue to do that superb job. Now, for everyone's information, written questions can be submitted for the record until 5 p.m. this Friday, July 17th. I hope, as the nominee, when you receive those questions, please answer and return them to the committee as soon as possible. This hearing is adjourned, but I want to say we'll reconvene tomorrow here at 9 a.m. for an executive business meeting, and that hopefully that doesn't take very long. Immediately following that business meeting, we'll have a panel of outside witnesses on this nomination. Meeting adjourned.
Thank you, Senator.
In the opinion of the chair, the ayes have it. The amendment is agreed to.
For what? Recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Texas will be postponed. The chair understands that amendments number 22 and 23 will not be offered. It is now in order to consider amendment number 27, printed in Part A of House Report 119749. For what purpose does the gentleman from Florida seek recognition?
Madam Speaker, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 27, printed in Part A of House Report number 119-749, offered by Mr. Stubbe of Florida.
Pursuant to House Resolution 1423, the gentleman from Florida, Mr. Stubbe, and a member opposed each will control 5 minutes. The chair now recognizes the gentleman from Florida.
Thank you, Madam Speaker. I rise in strong support for my amendment to increase the withholding threshold for assistance to Nigeria from 50% to 100%, while keeping in place benchmarks that demand Nigeria take effective steps to address the violence and persecution that continue to devastate the country. Nigeria has faced a horrific wave of violence that its corrupt government has failed to address. For years, and especially in recent months, Christians and other religious minorities in Nigeria have been subjected to violence and terrorism at the hands of extremists operating with impunity. Christian women and girls continue to be abducted, assaulted, tortured, and killed. Their churches are burned, and entire communities are erased. If the aid conditions included in the bill are important enough to withhold half of all the funding to the Nigerian government, then they are important enough to withhold all of the funding. The generosity of our taxpayers is a reflection of the American values we hold so firmly. Never should we allow their hard-earned tax dollars to be funneled to corrupt regimes that fail to uphold religious freedom, fail to adequately confront terrorism, and fail to protect the innocent from persecution. So why are we rewarding a government that fails to meet such a basic obligation? This amendment is simple. It does not remove the aid conditions in the bill, but only strengthens such conditions. But most importantly, it upholds a principle that all recipients of American taxpayer assistance should follow, that they must prove they are willing and able to respond to violence before receiving any funding. Simply put, meet the standard before receiving support. That is the accountability the American taxpayer deserves. Foreign aid should never be a reward for failure. So as our national debt is fast approaching $40 trillion, why on earth are we still allowing ourselves to go further into debt by rewarding corrupt foreign governments that tolerate terrorism within their borders? When churches are burned, women and girls are abducted, and terrorists operate with near impunity, that is not merely an internal disturbance, it is a direct assault on the freedoms our nation claims to defend, which our foreign assistance must reflect and uphold. This is not about punishing the Nigerian people. It is about demanding accountability for their government's complacency and ensuring that our foreign aid is leveraged to defend, reflect, and uphold American values. Even the underlying bill recognizes the Nigerian government's failure to meet the standard, yet it still allows for half of the funding to be released anyways. My amendment withholds all funds until they meet basic standards. Accountability can never be divided, nor should we allow anyone to exploit the generosity of the American taxpayer. I urge my colleagues to uphold accountability in our foreign aid spending and to vote for my amendment. I reserve.
The gentleman reserves. Does the gentlelady from Florida seek recognition?
Yes, Madam Chair, I am standing to claim opposition to this amendment.
The gentlewoman is recognized for 5 minutes.
Thank you, Madam Chair. This amendment would eliminate U.S. health development and security assistance to central government Nigeria. This would be a serious mistake. Nigeria is Africa's most populous nation, one of the largest economies, and a critical partner in promoting stability across West Africa. Our health programs prevent deadly diseases from spreading across borders and strengthen the capacity to respond to future pandemics. Our development assistance helps reduce poverty, improve education, expand economic opportunity, and address the conditions that fuel instability, conflict, and migration. Our security and assistance helps Nigeria combat Boko Haram, ISIS, and other violent extremist groups that threaten both regional and global security. And if the United States walks away, The challenges will not disappear. Our influence will. China and Russia will be more than happy to fill the vacuum, expanding their economic, political, and military influence at America's expense. Engagement does not mean writing a blank check. It means using American leadership to promote accountability, to strengthen democratic institutions, to protect human rights, and advance our national security interests. Walking away would make Nigeria nor the United States, neither of us would become more secure. And ironically, this amendment would end the very programs that this provision is trying to support. So it really doesn't make too much sense. I urge my colleagues to reject it, and I reserve.
The gentlelady reserves. Gentleman from Florida.
Thank you, Madam Speaker. This amendment does not end all assistance. It only strengthens the conditions and encourages the Nigerian government to meet them. Why should we give 50% of the money when the Nigerian government has not met the criteria established in the underlying bill? We are approaching $40 trillion in debt. Why are we sending funds to corrupt countries overseas that are unwilling to fully address violence and persecution? The generosity of the American taxpayer should reflect American values. We can't be putting ourselves more into debt to countries unwilling to uphold our values. The U.S. should not borrow money to subsidize foreign governments that fail to protect innocent civilians. If the aid conditions included in the bill are important enough to withhold half of the funding of the Nigerian government, then they are important enough to withhold all of the funding until the underlying conditions are met. The Nigerian government continues to fail to address violence in their country. Why should they still be eligible for funding given their lackluster response to the violence? Christian women and girls continue to be abducted, assaulted, tortured, and killed. Their churches are burned and entire communities are erased. I reserve.
The gentleman reserves. I recognize the gentlelady from
Madam
Florida.
Chair, I yield back.
The gentlelady votes back. Gentleman from Florida.
How much time? Can I inquire as to much time?
The gentleman has a minute and a half remaining.
Thank you, Madam Speaker. The underlying bill contains several conditions for assistance to be made available to Nigeria, which includes taking effective steps to prevent and respond to violence and hold perpetrators accountable, prioritizing resources to support victims of such violence, including internally displaced persons, actively facilitating the safe return, resettlement, and reconstruction of communities impacted by the violence, and allocating sufficient resources to address the aforementioned conditions. This begs the question, if Nigeria isn't meeting these conditions fully, why should they receive any funding? If they truly want the support of the American taxpayer, then they should be meeting these goals. Furthermore, while the underlying bill directs prioritization to address the atrocities occurring in Nigeria, they should be showing willingness to utilize the funding provided to address the violence before receiving funds. I yield back.
The gentleman yields back. The question is on the amendment offered by the gentleman from Florida. Those in favor say aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment is agreed to. It is now in order to consider amendment number 28, printed in Part A of House Report 119749. For what purpose does the gentlewoman from New York seek recognition?
I have an amendment at the desk.
The clerk will designate.
Amendment number 28, printed in Part A of House Report number 119-749, offered by Ms. Tenney of New York.
Pursuant to House Resolution 143, the gentlewoman from New York, Ms. Tenney, and a member opposed each will control 5 minutes. The chair recognizes the gentlewoman from New York.
Thank you, Madam Chair. The Temple Mount, or Har HaBayit, as it's called, is the holiest site in the world to the Jewish people. During the periods of the first and second temples, Jews from across the land of Israel would travel to the temple during the 3 annual pilgrimages. These pilgrims included figures like King Solomon, King Herod, Jesus of Nazareth, our Lord and Savior. However, whereas Christians and Muslims enjoy broad access and religious prayer rights at their holiest sites, Jews are severely discriminated against upon the Temple Mount. Muslims can currently enter the Temple Mount at 11 different gates, but Jews can only enter from 1 gate. Muslims can visit the Temple Mount any day of the week, but Jews cannot ascend the Temple Mount on Friday or Saturday or the Jewish Sabbath. Muslims have broad access to the Temple Mount and can pray openly upon the Temple Mount. Jews are severely restricted in their visits and do not enjoy the freedom to worship or the ability to wear their talit and tefillin upon the Temple Mount. And for Jews that ascend in spite of all these restrictions, they still face harassment from Muslims upon the Temple Mount. In fact, Muslim leaders have actively desecrated the site, including the planting and cultivating of trees at the inner courts of the temple, expressly prohibited by Jewish law. Muslim children play soccer, practice boxing, and have picnics upon the Temple Mount, desecrating its holiness, while Jews cannot even freely worship upon the Temple Mount. You don't have to take my word for it, Madam Chair. There's photo and video evidence of all this freely available. Individuals like Dr. Melissa Jane Kronfeld have spent extensive time documenting all of this. I want to thank her for her efforts to draw attention to this critical issue. Further, when one of my staffers ascended the Temple Mount last year, he was harassed by Muslim onlookers, restricted from visiting most of the site, and was only allowed to be upon the Temple Mount for a very short duration of time. Madam Chair, it's unconscionable that Jews do not enjoy the same access rights to visit and pray at their holiest site that other religions do. This is a basic tenet and principle of religious freedom, and the U.S. must do more on this issue. That is why my amendment would emphasize the need for the U.S. Commission on International Religious Freedom to work to ensure religious freedom and equal access for all with respect to the Temple Mount. I urge all my colleagues to vote for this common sense amendment and to support religious freedom for all and support the rights of the Jewish people to freely worship at their very holiest site, the Temple Mount. I reserve.
The gentlelady reserve. For what purpose does the gentlelady from Florida seek recognition?
Thank you, Madam Chair. I claim opposition to this amendment.
The gentlelady is recognized.
Madam Chair, while this amendment may be well-intentioned, it risks inflaming tensions at one of the most sensitive religious sites in the world. The Temple Mount is sacred to both Jews and Muslims. It's at the center of competing historical, political, and religious claims. And history has shown that even small changes to access or worship arrangements can spark violence far beyond Jerusalem. For decades, Israel, Jordan, and international community have worked to preserve the long-standing status quo, not because it's perfect, but because it has helped prevent broader conflict while difficult issues remain unsolved. The appropriations bill is not the place to insert the United States into one of the world's most delicate religious disputes. Religious freedom is a fundamental American value, but lasting progress at the Temple Mount will come through careful diplomacy, respect for longstanding efforts that preserve peace and stability, not through an appropriation amendment with 10 minutes of debate. I urge my colleagues to reject this amendment, and I yield back.
The gentlelady yields back. The gentlelady from New York.
Thank you, Madam Chair. I respect the opinion of my colleague across the aisle, but it was also said that moving the U.S. Embassy from Tel Aviv to Jerusalem was going to be too inflammatory and too dangerous. But many presidents said they would do it, and President Donald Trump did it. And it hasn't proven to be overly inflammatory. In fact, it proved to be the right place and the right thing to do. So I think that this is common sense. Why should Jewish people not be able to worship at their holiest site in equal measure that all other religions get to worship at their holiest sites? I think this is a common sense amendment. I don't think it would be inflammatory. I think it makes sense. And it restores dignity, and it also restores fairness to international human rights or international religious freedom tenets that we all stand for. Foundational type of religious freedom that we actually revere in this country in our First Amendment. I urge my colleagues to vote for this common sense amendment, and I yield back.
The gentlelady yields back. The question is on the amendment offered by the gentlewoman from New York. Those in favor say aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment is agreed to. does the gentleman from Florida seek recognition?
Chair, I move that the committee do rise now.
The question is on the motion that the committee rise. All those in favor say aye. All those opposed say no. The ayes have it. The motion is adopted. Accordingly, the committee rises.
Chair.
The Committee of the Whole House on the having had under consideration H.R. 8595 directs me to report that it has come to no resolution thereon.
The chair of the Committee of the Whole House on the State of the Union reports that the committee has had under consideration H.R. 8595 and has come to no resolution thereon. Pursuant to Clause 12A of Rule 1, the chair declares the House in recess subject to the call of the chair.
Mr. President, on vehicle stuff. The vans are all the way over there. We got our hustle. Go, 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 go.
Watch your step, guys. Watch your step. Watch your step.
Got it?
I was ready for that. How about you?
Yeah, I know, right? It's like fucking guy. You just can't not talk.
I know.
Watch for a hole.
Yep.
Don't run.
Get on the sidewalk. Safe. I'll go in first. You drop your sticks.
One's in front.
This is two. Woo! Hello. What is that?
Yeah, well, somebody put it in here earlier.
Yeah, well, I know. This does not work for. All right.
Test, test. Mic 1. Test, test.
Are we happy with that?
Just to clarify, I'm handing the national anthem singer the microphone on, and you will turn it hot.
Roger.
Ladies and gentlemen, welcome to the afternoon program. Please welcome to the stage our distinguished panel. Ladies and gentlemen, welcome to the afternoon.